I, Advocate Tarun Kumar, on behalf of Democracy News, we have been imparting many legal awareness to the people. Today, in the 10th edition, we are going to highlight about the criminal procedure, how arrest being made, how FIR been registered. This is a common to know each and every person of the society. Where police stations are located, police normally refuse to register the FIR. Now, before this, what is FIR? FIR is First Information Report under 154 of CRPC. Provision has been made how police officers are authorized to register the FIR and arrest and investigate the case according to the cognizable offences. Now, the Indian Penal Code, the provisions of penal sections are already laid down. Apart from that, there are many penal provisions in the acts. Accordingly, police are authorized to follow the procedure under Criminal Procedure Code, how to arrest the person. Before that, the informer has to go to the police station. Police will take his information, statement, then police will decide whether this arrest of the person is necessary for investigation. Accordingly, they will register the FIR, and FIR number will be given and copy of that will be given to the informer. Thereafter, police, before arresting the accused, they will inform to the accused the offense bearing number, crime, so and so has been registered against you for the particular offenses in the provisions laid down therein. Not only that, police has to inform that the offense registers are bailable, non-bailable, and you may seek the advocate for the opinion, and these are the punishable sections are registered against you. But these are the things police did not follow. Police don't disclose the facts to the accused. Simply they register and they call it and simply they push him in the custody. So again, here the violation of personal liberty and rights are happening in the society. Now, after the arrest, police has no right to detain the accused not more than 24 hours. Within 24 hours, they has to produce the accused before the magistrate for further custody and investigation of the case. And as soon as they arrest how made? Arrest has to be made with the panchanama, with the witness, with the body mark, and immediately he has to be examined with the government hospital, with the authorized medical practitioner. If the accused person is a woman, then lady practitioner or in the presence of the ladies, it has to be investigated or medical examination has to be carried out. Now, these are the common requisites which police did not follow and they did not inform. Police cannot arrest any person without any warrant or FIR. So they come to the house and they ask that yes, you come out, and immediately they said you come into our vehicle. It is not like that. We have a right to oppose. We have a right to know. We have a right to inquire with the police officer. Yes, what are the offences has been registered against me? Please to disclose, and accordingly I am ready to cooperate for the further investigation. At the same time, it is duty of the police to inform to the accused person that you may seek the help of the advocate during the interrogation. These are the provisions already laid down in the CRPC. But these things, police intentionally not informing to the accused, and simply they threaten and they give the unwanted harassment to the accused. After arresting, accused are also entitled. He should be given proper medication proper food, and proper examination from time to time during the custody. Police are empowered to investigation the cases, but it doesn't mean that they will ill-treat to the accused. Accused has a worse image in the society, so police officers has to be acquainted with the proper procedure. Then only civil rights will be implemented in the society to maintain the peace and calm and development of the civilized society. Therefore, under the Criminal Procedure Code, we have a right to oppose with the police officer. We have a right to know, and these guidelines has been given by our apex Supreme Court from time to time. Now, every person, whenever he has been called by the police, he can note down the name of the police officer, name of the person who is calling, and you can note down the name of the phone number, etc. Then only these arrest procedures can be invoked. After the custodial remand, when court has passed, when invoking the section 167 of CRPC, from time to time, limited period, police from time to time seeking the permission from the court, and magistrate will be directly concerning with the investigation officer. Without the permission of the magistrate, police cannot continue with the investigation. However, as per the procedure, police custody remand, police can obtain the police custody remand up to the 14 days. After expiry of the 14 days, police cannot ask for the police custody remand. Thereafter, it will be treated as magistral custody, or it is known as judicial custody. During that period, accused will be remain in the jail. But during the police custody remand, accused will remain in the custody of police investigation officer in the police station. This is the only difference between police custody remand and magistral custody remand. In the jail, the accused, again it will be numbered, he will be provided all the facilities as per the jail manual, and relatives can visit to the central jail or anywhere the accused has been kept for the particular said offences. During the investigation, the accused have a full right to know each and every part of investigation, and police officer has to communicate everything to the accused. Therefore, whenever any police officer comes for arresting and inquiry with any subjected affair or registered any cases, we have a right to inquire and right to know each and every facts from that police officer. Without quarreling or without any disturbing, we have a right to request in politely. If police officer fail to do that, police cannot arrest or detain any accused without following due process of law. For the awareness of the how arrest made, how FIR to be made, and how medical examination to be made, how to produce before the magistrate within 24 hours or not more than 24 hours, police can detain the accused in their custody in the police station. These are the common factors all the people should know, and this awareness will protect our civil rights. For hearing the democracy news, thanks. Again, we'll come up with the next session.